breach of duty with potential malfeasance both on the part of the mayor and the city clerk. The heart of the mayor is whether the mayor's refusal to schedule a special meeting requested in writing by 2 city council members in July in compliance with state statute 442-191 in fact constitutes a failure to perform official duties on behalf of both the mayor and the city clerk, and the council's inaction constitutes any liability. State statute 4202 mandates that the city clerk must schedule the meeting promptly upon such request. She did not. In fact, all she did was alert the mayor, who also denied the meeting, as soon as she found out that it pertained to performance issues and it raises serious legal and ethical questions. In state statute in Minnesota 4202, the mayor has a role of overseeing the city's administration, but does not possess the authority to unilaterally deny a legally valid request for a special meeting. The refusal based on the content of the request itself, literally when it comes to a performance issue of a mayor, is a misuse of authority. The clerk and the mayor's refusal may constitute malfeasance as it represents an unlawful act performed by a public official. Malfeasance encompasses the commission of an act that is legally unjustifiable or harmful to public duties. Additionally, from an ethical perspective, the refusal undermines the principles of transparency and accountability and governance to allow the city council to deliberate on matters related to the mayor's performance or attendance, and it can be construed as an attempt to obstruct oversight and accountability. The responsibility in this, however, lies with the city clerk to schedule the meeting by law, and the mayor for the statutory process that requesting council members have had several avenues of redress of grievances. Now they have more, including a judicial review, a declaratory judgment, or ethics complaints, and most importantly, civil action, should the mayor and clerk's action be deemed unlawful and harmful. I'm not a judge, I'm not saying that. The city council members could pursue a civil action for damages resulting in the obstruction, though that route may be a little more complex. Conclusion is that failure to schedule a special meeting by the city clerk and the mayor's refusal to, due to the content of the request for like significant breaches of duty, may involve both malfeasance and misfeasance. This, yet again, Twin Lakes, is one of dozens of laws that these two in particular continually break and flaunt without any regard to financial liability or litigation from the city and costs therein. When the heck is it going to end? I'm going to answer for you. It's going to end in November for the elected officials. For the employees, it might end even sooner, because all it takes is a vote by city council. And Matt Benda is bilking this city out of hundreds and hundreds and hundreds of dollars while he sits on his hand and doesn't answer things that he's legally responsible to answer. And I think you all know what I'm talking about. And in closing, I'll just share with you. If you don't believe me, go look up the public data on the MnCourt's website, because your lawsuit for failure to answer the public data request was served today with the courts. It's certified, and the minimum award is $9,000. The maximum is $90,000.
And who filed